Welcome to the Lawyers Weekly Show for an in-depth look at the issues facing the legal profession.
Hello and welcome to another episode of the Lawyers Weekly Show. My name's Jerome Doraisamy and I'm coming to you today from Camaragal Land in Sydney. I'm very pleased to be joined for this conversation in the studio by Melini Pillay, who is a principal at McCabes. Melini, welcome.
Thanks for having me, Jerome. Excited to be here.
It's lovely to have you. Now, today we are going to be discussing the need for employers to look at revamping their social media policies in the wake of the recent proceedings between Antoinette Lattouf and the ABC in the federal court. We're going to be covering what happened in that case, in case you've been living under a rock and don't know what happened, but also what are the key takeaways and lessons for businesses and organisations across the country as they navigate best practice when it comes to social media use by their staff. Melini, before we get into all of this, could you tell our listeners a little bit about yourself and the work that you do at McCabes?
Sure. So at McCabes, I joined in March of this year as a principal, and I'm essentially building a practice that covers employment and safety matters. So my background up until this point is probably a little bit different to some other employment lawyers. I actually started my career 20 years ago in criminal law at the Legal Aid Commission, and was lucky enough to have sort of mentors like His Honour Justice Button, who's now retired, and John Stratton and Winston Terracini of King's Counsel, who taught me, amongst other things, how to write, advocacy and how to assess evidence. And then I took all of that experience and transitioned into being a safety prosecutor and then a prosecutor at the Fair Work Ombudsman, and then came full circle back into defending at Australian Industry Group and then PwC and now at McCabes.
Yeah.
So, yeah.
Well, it's quite a journey, and I was wondering when you first said it, what would be the connection between criminal law and then employment and safety law, but from what you then went on to describe, it makes a lot of sense. And what made you want to move from the prosecution side over to defence?
Oh, because I'm a bleeding heart, but also it's safety matters are really difficult to defend. I mean, it's a no-fault jurisdiction. Most incidents aren't intentional. People don't really want to hurt their workers. And it's really hard to defend a prosecution. So when I was prosecuting, I felt really sad for some of the businesses and individuals that were being prosecuted, and I had to flip sides and prosecute. But it is actually quite a natural transition from crime into safety, because even though safety workplace law is always combined with employment and industrial, it's actually more criminal in its nature. It does require an assessment of a charge, an assessment of evidence, you know, where employment matters don't generally in the same way.
Yeah, so now that you've explained it, I can understand why it might be useful to have that background, but I can't imagine there's too many employment and safety lawyers out there who have also worked in the criminal law space. So, I mean, how do you feel like that gives you a perspective or insight that perhaps some of your colleagues don't have?
Yeah, interesting question. I think what it does is it's sort of, well, one, I think it more importantly, it gives you greater access to understanding evidence, because it's everything that you're doing in crime, and police as investigators are probably at the highest level of investigation by comparison to any workplace investigator or any regulator might be. And so when you're reviewing and assessing their investigations and their recommendations for charges, I guess you're looking at it at the highest level. You're assessing evidence at the highest level. So there's that aspect. And then there's also the people element. I mean, when you're representing people like the clientele, particularly at Legal Aid, who are from a socioeconomic deprived background, you're sort of connecting with people who haven't had the privilege or advantage in coming to a system or making choices always in their conduct. And a lot of that rings true for being an employment lawyer, because what you bring with you is empathy and sometimes sympathy, but also just emotional intelligence in decision making. And and I was just going to say, and some of what you sometimes see is people hold employers or their managers or executives to this really high, almost impossible standard, And the reality is they're people,
Yeah.
and we're all flawed,
Yeah.
and we all make decisions based on what we know.
Yeah. Just further on that point about the high standard that businesses and employers have been held to, when you look across the landscape of safety-related legal matters, I mean, do you find that working in this space is becoming increasingly complex or complicated or difficult, or is it somehow becoming easier and more streamlined? I mean, what's your take on the lay of the land?
So my opinion would be that it's becoming harder. It's becoming more heavily regulated. The society expectations are also increasing. Generational expectations are also increasing because, for the first time we've got about 4 generations, I think it is, in the workplace.
I think it's 5, actually.
Is it 5?
Yeah.
This must be 4 soon, though. At what point does that...
Yeah.
But in any event, we've got like all of these different generations, and they all have different perceptions and they all have different sort of abilities to raise issues. And from what I can see, the younger generation that are coming through are more aware of their rights, more willing to complain or to raise questions about their treatment. And as a result, the regulation, particularly in the safety aspect, is just increased. But also, even if we look at the numbers of prosecutions that the regulator is bringing, it's increased almost threefold, I think. I mean, back when I was a prosecutor, there were sometimes about 50 prosecutions before a court in any year. And I think now there are about 200 in the new industrial relations court.
So what kind of challenges does this present for a safety lawyer like yourself? How can you move forward and ensure that you are not only keeping pace with all of these changes out in the market and with societal and worker expectations, but then also ensure that you are delivering, the best service to clients? Yeah,
look, it's a great question. And I think partly what we're doing is, I'm trying to do the educational aspect, so the preventative component of it. And I'm working a lot at the moment in psychosocial safety and doing a lot of presentations and a lot of webinars to broad audiences and trying to collaborate with people so that we can reach as many people as possible. And then I think also it's just putting out material so that people are aware of their obligations as they pertain to the safety legislation. I mean, it's really sad when I have a client at the moment who said, I had no idea. I had no idea it was this significant. I had no idea that we had to do these things. And I think that missing educational piece that still exists now is really concerning, but something that we can address as safety lawyers in the market.
Definitely. So, Melini, let's talk about the recent proceedings between Antoinette Lattouf and the ABC. Now, this matter was pretty prominent, in media outlets across the country. But for those who perhaps weren't following it closely, past the headlines that they might have seen online or in the papers, would you mind giving us an overview for the proceedings that took place and how and why they came about?
Yeah, so it was heavily mediatised. It was, in fact, more than any other employment matter that I'm really aware of, even all of the ones that have run to the High Court. So Lattouf was an employee of the ABC. She was engaged on a 5-day casual employee to be a presenter. And during the course of those 5 days, I think on around the 3rd day, the ABC became aware of a post that she had made, and the court later found that it was just a request that she not post information that was, controversial, that might show an opinion or a bias. And then subsequently she posted a video, which was actually just a reshare rather than a post, of a Human Rights Watch video that depicted some images of starvation to children. And shortly after that, she was taken off the air and told that she didn't need to continue with her engagement, and she was told that there was a breach of policies and guidelines. No further information or sort of detail was given to her for why that occurred.
Yeah.
I think one of the most common responses that I've heard just amongst conversation is people saying, why didn't the ABC just let the 5 days run?
Yeah.
And let it naturally lapse, and the issue would have, resolved itself. They didn't have an obligation to engage her back. It could have just ended there.
Yeah.
And I mean, going back to what we were saying about people, my first response is usually, well, if everyone made perfect decisions, I'd have no job.
Yeah, that's true.
So let's not. But also employers are also people. They're individual decision makers who are making decisions. And again, we do hold them to a high standard, but they are fallible and flawed, and people do make mistakes. And I'm not suggesting that that is what they've suggested they did here, but the court ultimately found that there were reasons for the termination. So they identified one decision maker, which I think was the chief content officer for the ABC. And the reasons for his decisions were that he had thought that there had been a breach of their policy, and that she had expressed a biased view on a matter, and that the ABC could face accusations of supporting or facilitating her views. And then there was a further reason that the court didn't associate with an expression of her personal political views that led to the termination, and that was that the ABC had terminated her to protect its image or try to contain its any reputational damage by affecting the termination.
Oh, sorry. Did you have
no?
Oh, okay. And then ultimately, what was handed down by the court?
So a decision that they had breached the general protections provisions and they had terminated her for expressing a political opinion, which is a protected right in the workplace. And the damage was, I think the damages were $70,000 for non-economic loss that she received, by comparison to the ABC's legal bill, which I understand is reported to be about $2 million.
Yeah, and correct me if I'm wrong, but I think that particular order is still yet to be handed down. So, the costs for our national broadcaster for contesting, these proceedings and not settling are going to be significantly higher for them and ultimately for us as taxpayers.
Yeah, exactly. Yeah. So those decisions had some real implications to them.
Yeah. So from an employment law perspective, what do we see as being the headline takeaways here for businesses?
Yeah, so for businesses, I think it's complex. I think social media in general is really complex. I'm not sure that we ever envisaged that it was going to be utilised in this way. And I remember, 8 years ago when it was right at its infancy, drafting social media policies and just putting in the line to say, please make sure your personal page says that you're expressing your own views and not the views of your employer or whatever it might be. And most people have a statement to that effect or something similar. But social media has evolved. I mean, we're inviting people into our workplaces. I don't know about you, but my feeds are constantly full of people doing the look at me in the office having my breakfast and here I am in my meeting room having a meeting. So we've invited social media, whether by choice or otherwise, into our workplaces, and the parameters for control and monitoring are just different.
Yeah. Well, not just that, but a lot of businesses are now posting a lot of video content of their workplaces and, showcasing the staff that work there. From your sort of observations or perhaps, from, reading over workplace policies for your clients, do you have a general sense of the extent to which businesses are producing detailed, specific policies around the use of social media? I mean, my perception is, and maybe this is an outlier, but my perception is that most workplaces will have a pretty vague policy around the use of social media by individuals, something along the lines of, you're free to use social media at your discretion, so long as you don't bring our business into disrepute, or something to that effect, which is a pretty broad kind of framework to have, and it leaves a lot of potential wiggle room. I mean, who's to say what constitutes disrepute? Does that account for someone's political or religious or other biases that they may have? From what you can tell, how detailed and specific are these social media policies right now?
Well, in my view and my experience so far, I don't think anyone's really willing to put out a detailed policy. I think that the vagueness of, don't bring us into disrepute is kind of the highest that they can put it, and it gives them the opportunity to consider any posting or conduct or complaint in its own sort of discrete form, rather than have some really prescriptive policy that they're then stuck with saying, well, it doesn't actually offend this and, it doesn't really breach this. But the challenge is that it could be anything. The conduct can bring the organisation into disrepute, and were complaints made by the organisations that the ABC said that they'd received complaints by in the Lattouf matter. It could have brought their organisation into disrepute. They could have had a view that they didn't, agree with, and that they did think that the ABC was facilitating or supporting this view being shared. And the challenge is then, how do you respond? How do you respond to that? Do you say, well, actually, no, that's our employee's post and our employee is entitled to her own views. There's nothing in that post that should be drawn or connected to the workplace. We're not referenced in this post. There's no suggestion that she's attempting to connect us or reference us with us. But it becomes a very fragile connection, the employee's post and the employer. Because once somebody makes that connection, it expects you to exert that control over your employee, you feel a need to stop and think, well, can I? And it's a really tenuous line, and I don't know really where it falls.
Yeah, and obviously we're going to get into how best employers can look to review some of these social media policies that they have for their workplaces. But it sounds as though, from everything we're talking about, that there really isn't a perfect solution here. That if you overprescribe, then you are really boxing in your staff members. And if you make it too broad, then they can just take the piss.
Yeah, I think that's probably pretty right. And, I'm always really conscious of the fact that it can also just be two employees. I mean, I could make a post and a colleague of mine could be offended by it, and they could raise that as a complaint to, my managing partner, who would have to then consider, so Melanie's made this post. It's on her Instagram page or it's on her Facebook page. It's got very little to do with the workplace, but it's obviously something that she feels strongly about. And what do you do? Now you've got another employee in the same workplace who's upset, offended, disagrees with it. So to some extent, you have to address it. You can't disregard it. Yeah. But to the same extent, how can you control me?
Yeah. And it seems as though there are so many different ways in which a viewer or reader or, a consumer of social media might get offended by somebody's use of various social media platforms. So, for example, if you use Instagram to post a photo of yourself in a bikini, maybe a prospective client would think, well, this person's not professional. Or if, you're on a dating app and, you happen to say, I'm a lawyer at McCabes, is that bringing the firm into disrepute? And reasonably, I think the lawyer or employee in that scenario would say, how on earth have I brought anyone into disrepute? But I guess it can be hard sometimes to counter people's, idiosyncratic perceptions.
Exactly. And that's the challenge, right, is that it's people. People are by nature unpredictable and difficult to invariably are going to all have different views, different perceptions, different biases and different standards. And you cannot, and what applies to one, you can't apply to the other. So you really can't, put in place a policy that respects or that addresses every single person's position on something. Yeah. And there is also, and I mean, maybe this is me, but there is also, I think, a bit of a view to constantly want to hold someone responsible for something that may very well be outside their control. Yeah. And by that I mean we do hold employers to a standard sometimes that is well outside of their control or has very little to do with them. And I would say sometimes that an employee expression of an opinion or something, a discussion is linked to the employer in a way that it may be unfair.
Yeah, I suppose there's a lot of that happening when it comes to cancel culture these days. Yes. So, if somebody posts something that is inflammatory or controversial, you then might get people tagging their employers saying, do you condone this kind of language from your, CEO or whoever it might be? And Yeah, I mean, look, sometimes if somebody has said something completely out of bounds and completely reprehensible, then maybe that is appropriate that they lose their job.
Yes.
It's a slippery slope.
It really is. It makes me think of the Coldplay concert because,
Yeah.
we all saw what happened to the CEO who was, undoubtedly skilled and capable at his position but had to step down following, this disclosure of this affair.
Yeah.
But yeah, it's that people are held to a higher standard and sometimes have to answer to that.
Yeah. Well, let's talk about how best businesses can respond, and we'll get to that on the other side of this. So, Melanie, when it comes to a review of social media policies, this is obviously a timely conversation for us to be having, given the recency of the findings in the matter of Antoinette Lattouf against the ABC, and what the ABC will ultimately have to pay, for that unlawful termination. As a starting point, what do you see as being the most important questions that an employer will need to ask of itself when it comes to any kind of review of internal policies?
I think an employer needs to consider what it wants social media to be used for the business, firstly. So what's the business purpose? Do you want your employees to be, advocating that you're a great employer and showing people what a day in the life being an employee of your organisation looks like? And in which case, because that can add interest in a business as well. So in which case, I think you need to be really clear about that and that you're encouraging this sort of use of social media and perhaps put some parameters around it such that, they do ask for permission if one of their colleagues is going to feature in the background, or that they have permission if they're going to, use an office space within their workplace environment and things to that effect. And also if they're going to show the hours that they might be working as well. So things to that effect, I think that they need to have some parameters around how they're going to approve of their employees using social media and how they're using social media themselves. And then I think they need to have some sort of a broad description around, where or to be conscious, more like a guideline or a thoughtful position to say, your positions on certain things and your views and your expressions can have the ability to offend or humiliate or hurt others, both your colleagues within the workplace, potential or prospective clients or existing clients of whatever the business might be. And we ask you to be mindful of those matters. Yeah. They might want to have some directions around things. Like, for example, I often say to people, if you have a LinkedIn profile and a photo that's your professional photo that might be owned by your employer or might be or have been taken by your employer, perhaps don't use that same image across, your Instagram or your Facebook or your Twitter. What's the new name for Twitter?
X.
There you go. I'm not on it, clearly. That, where you might be making comments or posts that are more controversial than what you might put on LinkedIn, or that you might not want that direct association with your employer, but parameters to that extent. So, and perhaps be mindful about what you post on LinkedIn as opposed to what you will use on X or Instagram or Facebook. Again, just speaking to the audience and the fact that LinkedIn is a more professional social media platform.
Yeah. Do you think that employers need to appreciate that social media is so prevalent in our day-to-day lives now that almost nobody is not on social media, and it'll take mere moments to link somebody to their employer. If you do just a cursory investigation of who somebody is, and that given how prominent social media is in our lives, that maybe our policies in the workplace need to be as accommodating and maybe flexible as possible, given that the horse is bolted on the platforms being in our lives?
I think that's probably right. I think also society needs to come up to speed with that as well.
Yeah.
Because, a lot of the times the complaints are from other businesses. They are from organisations. They are from other people who are trying to hold or they're from the media that are trying to hold this employer responsible for its employee, when everyone is on social media. Those platforms are massive, and the ability to control, leave aside, monitor is impossible. If you have 1,000 employees, how are you supposed to be across what every individual is posting or doing to know? And sometimes you are alerted to these things by a complaint internally or externally. Or in worst case scenario, the media.
Yeah.
But I think there needs to be some sympathy in that view, or some recognition in that response that recognises we understand that this is your employee and you may not be able to do much about their view, but it's offensive to us, and if there is something that you can do, that would be great. But threatening to remove your business from an employer because of something their employee posted, it's probably a bit harsh in this day and age.
Yeah, well, and obviously we've seen that with more than just the Antoinette Lattouf matter. It happened with Israel Folau and Rugby Australia, and Scott McIntyre with SBS. And of course, Melanie, we also have the implied freedom of political communication, as per the High Court judgment from a number of years ago. So yeah, in the face of all of these decisions, I mean, it seems pretty clear that employers perhaps can't be too prescriptive about what their employees can or cannot say. On social media, they do have the implied freedom to say what they want, and in the social media day and age, they have the capacity to do so. And going back to the societal expectations shifting that you were talking about a bit earlier, we have to allow staff to I guess, communicate and socialize as they see fit to an extent. It does mean that maybe we need to shift our expectations of the employers.
I think that's right. I think ultimately that's right. And I think to put pressure or make an employer feel like they have to take some action to impact this individual who's posting's employment, whether it be a termination or a warning or a stand down, I think that's going to have to be the thing that shifts most. I think we're going to have to reconsider it. And at the moment, really what we're saying to employers is take a breath, take a minute, don't react quickly, because there are too many things at stake that need to be weighed in that decision-making process.
Yeah. So in reviewing and updating the social media policies for your business, how best can the C-suite, the HR team, any other relevant stakeholders, how can they all be getting together to figure out the best pathway forward? Is there a black and white approach that every business should be taking, no matter how big or small, or is it going to have to be case by case?
I think it's going to have to be case by case. I think it's going to be really individualised to specific businesses, particular industries even maybe, and also to your specific workforce. I think it's going to take a real understanding of, where it's at. And you look at sort of professional services and consulting environments. I mean, posting is prolific at the moment. It is just everywhere. You can't avoid it. Yeah. And to try and lean in to try and control and monitor that is going to be hugely unsuccessful and wildly unpopular. Yeah. So, you're going to have to take a really liberal approach with and just some broad stroke measures of if this happens, we might have to have a discussion, or, you might be requested to remove something or something to that effect. But I think that's the best that you can really do. It has to be very discretionary, and it has to be very case by case.
Yeah. And just finally, Melanie, what advice would you offer to employers out there who are going to be undertaking these steps moving forward? Obviously, no employer wants to be in the position that ABC was or Rugby Australia was. So how can they be viewing this project moving forward so that they can ensure that everybody wins?
Yeah, I think the best thing is to have a consultative approach to the process. I think having some leaders in your workforce involved in, how they're seeing social media being used, reviewing any of the complaints or issues that have arisen already with your social media and addressing them in a revised policy would be ideal as well. And then just keeping some broad positions available for you to have some ability to act if you really need to, or to at least contemplate what actions you might want to take if you need to. But I would say that you probably need to revise your policy with some advice or with some guidance, and not try to just do it on a whim like how we used to do 10 years ago.
Yeah, absolutely. Melini Pillay, thank you so much for your time.
Thanks, Jerome.
And thank you to the listener for tuning in. If you enjoyed this episode, please give us a rating and review on whatever platform you use to listen to podcasts, as it'll help other lawyers discover and enjoy this show. And if you've got ideas for other episodes we can run, please get in touch at editor@lawyersweekly.com.au. You can also reach us on social media. See you again next time.